Real life. Okay, good morning. We're back in Senate Judiciary on February 10th at 10:32. We have S-179 in front of us, and we have Matt Getty here to testify. Just so the committee's aware, there are some printing difficulties. So we have the bill as introduced from pages 1 to 13, but we're missing the last 3 pages. I'm sure we'll get those shortly. And Mr. Getty, we haven't yet gotten a walkthrough from our legislative counsel on this bill. So this is, I believe, the first time we're laying eyes on it. So happy to hear your testimony, but also if you want to provide the full committee just a general overview on what this bill does and what it proposes to fix, if anything. And yeah, so the floor is yours.
Okay, I can do that. I guess first, let me just introduce myself. My name is Matt Getty. I'm an attorney in Rutland, focusing on estate planning and probate. I was um, I guess the foolishly volunteered for the role of chairman of the Vermont Bar Association study committee on this topic that reviewed the uniform bill. Proposed some modifications to it for Vermont purposes and passed it on to you folks. Want to just briefly thank the other members of the committee that included Mark Langen of Dincy, who is the chair of the Trust and Estate Committee or section of the Bar Association, Mark Melendi from Sheehy, Furlong and Beam, Allison Wells Sherman of Downs, Rackland Martin, Carol Pfeiffer, also of Dincy, Steve Schindler, and Jim Dingley. So I can certainly provide you with an overview. I just want to highlight, I guess, what I see as the main points of this bill, and then we can go through it in more detail, section by section, if you like. So I guess the place to start is, what is this about? What is a disclaimer? A disclaimer, for purposes of this statute, is a refusal to accept something. So typically this would arise in, say a probate situation where maybe you're inheriting something that you don't want. And that there could be a tax and estate planning reason why that's the case, or there could be other reasons why you don't want to receive an asset. And so the law allows you to disclaim that asset, which means basically throw your hands up. I don't want it, hot potato, it goes to somebody else. And the law then says what happens in that scenario. So Vermont has an existing statute on this subject, which was modeled on an earlier Uniform Act, and that was adopted, I believe, in 1985. The current version of the Uniform Act on this subject, which you're reviewing now, was originally adopted by the Uniform Law Commission in 2002. There have been a few technical amendments to it since then, but it's been around for a while. So it's actually been around now longer than Vermont's current law was on the books at the time that this version was adopted by the ULC. So we're a little bit behind the times from that perspective. So one of the characteristics of Vermont's existing statute and other state statutes that were adopted around that time is that they tended to be geared towards matching the requirements of federal tax law. And so one of the key features of disclaimer law for tax purposes is that the disclaimer must be made within 9 months of usually the individual's death. And so that's what Vermont law said. There was a 9-month clock that was ticking on your ability to disclaim. Um, However, our existing law in Section 1952 actually contained a provision that was inconsistent with federal tax law with regard to future interests, which we don't really, I think, need to get into in detail here. But um, the notion is that um, the state law focus on the 9 month timeline was really unnecessary. Um, it may be the case that most disclaimers are made for tax purposes, but there can be situations where that's not the case. For someone who is looking to make a tax qualified disclaimer, those folks should be looking to the tax law for guidance on how to do that. And so one of the major things that this law does is remove that 9 month deadline. The state law requirements for making a disclaimer would no longer be tied to or trying to match the federal tax requirements. If somebody wants to make a tax qualified disclaimer, they look to the tax law for that only, and hopefully thereby avoid any conflicts between the state and federal law. So, so currently, just to emphasize, under state law, there is no provision for making a disclaimer um, outside of the 9 months for non-tax purposes. So if say there's a delay in getting a probate started and you're well, frankly, you could be 9 months past a person's death before a probate gets started for some reason, but maybe you're less than that. Maybe it's 7 months after, and then but by the time somebody realizes what they might be getting and that they don't want to receive it, it's too late to disclaim, and then they need to receive a distribution and turn around and make a gift, etc. So this would allow a disclaimer in that scenario, even if the 9 months has passed.
Matt, can I interrupt real quick?
Yep.
I just want to make sure I'm understanding that if it's that the purpose of the disclaimer is as it relates to estates and trusts, or is it as it relates to taxes? And I think I'm still a little unclear.
So I'm not sure if I heard the middle of your question with the door open, but there could be estate tax planning reasons why you would want to disclaim, but there could be other reasons. For example, there's you're going to inherit a toxic waste pit and you don't want it. Uh, the law would allow you to disclaim it. For tax and estate planning purposes, I mean, I can get into that more if folks are interested, but the general idea is that you might disclaim something to avoid it being added to the value of your estate. So that, let's say, so for Vermont purposes, the individual estate tax exemption is $5 million. So if the value of your estate is more than that, you may wish to not receive something and maybe have it skip you and go to your children or whatever other effect might occur under the decedent's will, but you may just not want to receive an asset that is going to be subject to the estate tax. And so you have the ability to do that under current law. And so one of the points I wanted to make was that this statute, this amendment is revenue neutral uh, for the reason that it makes no change to the existing tax law. The existing law that applies to gifts and estate tax in Vermont is still the same. This just updates and gives more detail to how a disclaimer can be made, which we can talk about that as well. But it's really putting more meat on the bones of what the current statute has, and it's removing the 9-month deadline that we just discussed. Those are, I would say, the main highlights.
Thank you.
So, as I just indicated, this statute does provide more detailed rules on how one goes about making a disclaimer for various types of assets and how you would effectively deliver that disclaimer in order to provide notice to people that need to know that it's been done. And so, and included in those sort of new rules are rules on disclaimers for jointly held property, rules for disclaimers by trustees of trusts who might be, if in a scenario where a trust might be a recipient of property, and as well as new rules for disclaimers of powers of appointment, which is again a tax-related subject that's not treated in our current statute. The statute includes a provision expressly stating that an effective disclaimer is not a transfer, assignment, or a release, which I don't believe was in our current statute, but that's found in Section 4105, subparagraph G of this bill. The overall statute is longer as a result of these provisions being included, but in my opinion, it is easier to use as a result because you can kind of go through the table of contents and say, like, here's my situation. I've got this particular asset that I want to disclaim. How do I deal with that? What do I need to do in order to make that disclaimer and effectively deliver it? And then, the last bullet point on my list of highlights was the revenue neutrality that we talked about. So we can go through the provisions section by section. I do want to highlight for you folks, I had sent over a suggested edit to the House. They have a companion bill over there, and that was in section 4105, subparagraph C. And that was this, the suggestion is to remove the words or incapacitated from that paragraph. That change is suggested in consultation with the Uniform Law Commission as well as our study committee. That's a provision where we had proposed a deviation from the standard language in the uniform law. We were inspired by a provision in another state. And on further reflection, we think that the removal of those two words from that section would avoid some potential ambiguities in the future. So I guess I'd pause there if you have questions on anything I've said so far. Otherwise, I can do more of a walkthrough section by section.
Yeah, I think, well, committee, are there any questions? Oh, I don't think we have any initial questions. If you want to provide a general overview, I mean, we'll also be getting a walkthrough from our legislative council, but if you want to provide your perspective on the different sections and, summary of what each section may address, that would be helpful.
Yeah.
Oh, and I see one quick. I also see our ledge council hopped onto the Zoom. I don't know if Eric.
Yeah. Can you hear me okay, Senator Hashim?
Yes. I can hear you. I know we don't have you on the schedule or the agenda for today. And yeah, I don't want to put you on the spot. I think maybe I just made an error and didn't schedule a legislative council walkthrough prior to witness testimony, but happy to get a walkthrough in the future.
Right. But actually, and I'm happy to do that. But also, you were right, and I think I mentioned this to Emery that usually with uniform acts like this, the initial walkthrough is done by because they're not drafted by us. I mean, we certainly go through them for formatting and to make them consistent with the numbering and those sorts of issues with related to the Vermont statutes. But generally speaking, the first walkthrough is done by the chair of the VBA committee that drafted the language in the first instance, which, as Matt pointed out, he was fortunate enough to be that person this time around. So yeah, I think you're right on the money to go ahead and
Thank you.
I'm sorry I'm not there. For some reason, I can't get my camera to work, so I'm glad you can hear me at least.
No worries, no worries. Yeah, thank you.
Yeah, thank
yes.
you.
You want to proceed? Happy to get the walkthrough for you.
Sure. So, section 1 is the title. That one's easy. Section 2, definitions these are generally self-explanatory. I would note that we did add a definition of the term personal representative, because that is used various places throughout this act, but it's not otherwise used in Vermont law. So, we've added a provision in here to aid understanding. Section. Oh, and I would just add as I'm sort of scrolling through, and I've got all the comments, the uniform comments and the comments that we added in front of me, and I don't know what the plan on that would be. I know that when the Uniform Trust Code was adopted, all of the comments, including specific Vermont comments, were published in the official books, which can be quite helpful. It's of course anyone could go to the Uniform Law Commission's website and look up what their comments are, but it those are really key in some cases to interpreting the and understanding the provisions of the law, and the Vermont comments would point out, where we may have made changes. So
Could I interrupt there just for a moment,
Yep.
Senator Hashim?
Yes, please.
Just so Matt knows, and we hadn't had a chance, and the committee knows too. Our office's procedure on that is that if the Uniform Act does ultimately pass the legislature and signed by the governor and becomes law, then at that point in time, early summer, midsummer, that sort of thing, if the committee wants to have the comments included, then they would send them to me through our office. And same thing if you wanted to have Vermont comments that were specific to maybe changes you may have made or whatever instances you thought that would be helpful, you'd send those along as well. And then we work with the publisher to make sure that they're published in the Green Book. So that's how that works. Just an FYI.
Excellent. Thank you. All right, section 3, self-explanatory. Section 4 says that other law may supplement provisions of the statute if there are developments in common law that might apply to a situation. Section 5, power to disclaim. This section describes generally the right to disclaim and who may do it. We added subparagraph C, which was inspired by another state, and this is where I was mentioning earlier.
Matt, what page are you on?
Well, let's see. Let me flip over to the Act version of this.
Because we're looking at the bill as introduced, and there's only one section.
Okay, the version I'm looking at is section 4105. And that's, let's see, page 3, starts on the bottom of page 3.
Got it. Thank you.
Okay, so in subparagraph C is where I'm suggesting to remove the words or incapacitated, which appears on the third line of that subparagraph. So just generally, in this section 5, again, this in setting forth the requirements, there's no 9-month deadline. But this does describe the basic requirements for the content and delivery, which is detailed further elsewhere in the statute. And again, this section provides that a disclaimer is not to be treated as a transfer of an asset. The other change that we made from the Uniform Act is we expanded the meaning of the term signed in order to accommodate physical limitations for anyone who is trying to execute a disclaimer. And so the language we use there is consistent with our will statute. Section 6, 4106, I guess. This is the section that describes what happens as a result of a disclaimer. So it tells you who gets the property if you disclaim it. And frankly, you kind of have to walk through the scenarios there to figure out the result. And I don't think that we need to go through it, but that's what that section is for. Section 7 speaks specifically to jointly held property. There was some language in existing law, but this language is much more detailed. And again, this is one where the comments will be key because it gives a lot of explanatory examples on how this works. And the language in this provision is intended to be consistent with federal tax regulations. Section 8 talks about disclaimers by trustees. So if property is granted to a trust, the trustee of that trust can disclaim the asset. Section 9 speaks to powers of appointment and other non-fiduciary powers. So if say a trust grants an individual a power to direct where property goes, that's what a power of appointment is. Or some other power that they can disclaim the power that the trust gives them. And again, typically there's a tax reason why they may want to do this, because maybe they've been given a power that causes property to be included in their estate for estate tax purposes, and they don't want that to happen. So they disclaim the actual power itself.
Can I interrupt real quick and go back to 4108? There, 1 second. So I see that if a trustee disclaims an interest in property that would have otherwise become a trust property, the interest doesn't become a trust property. And I can't find the other section where I think it described what would happen, but if it doesn't become a trust property, then what happens to that interest?
So that would be the previous section, section 7, 4107. Back two sections. So in section 6, you would go through that.
Okay, is that line 17? It's not an individual.
Yeah, hold on. Let's see. Yes, I think that's correct.
Oh, thank you.
Okay. Let's see. Section 10 allows for disclaimers by an appointee, meaning a person who could receive property by virtue of somebody else exercising a power of appointment. So we're getting a little bit attenuated here, but um, again, it's another scenario where a property might be coming to you and you can refuse to receive it. And that's a subject that was not addressed in the current statute. The section also makes clear that you had the power to make that disclaimer either before or after the appointment. And we made a small modification to the language there that we felt made that section a little easier to understand. Section 11, it has to do with the disclaimer of fiduciary powers. So here again, you could have an individual serving as a fiduciary who does not want to have a particular power, and that can occur for tax related reasons. But conceivably, there could be non-tax related reasons why a trustee doesn't want to have the power to do certain things. And so they can disclaim that power under that section. Okay, section 12 speaks to delivery or filing. And so this is the section that tells you what to do with your disclaimer in order to effectively put other people on notice. So it goes through various, specific directions for how to deal with different kinds of assets. We added a specific reference to enhanced life estate deeds since those have particular statutory authority under Vermont law. The Uniform Act it was organized a little bit differently around subparagraph G having to do with beneficiary designations. Some states have what I think were called pay on death deeds, which, as I understand it, are effectively the same as enhanced life estate deeds, but they call them something else, and they there's authority for them under the Uniform Probate Code, which we don't have. So we've just changed the language there and reorganized a couple of paragraphs to specifically reference Vermont's enhanced life estate deeds. And we added the subparagraph H to deal with real property generally. And this provision requires that when disclaiming an interest in real property, that the disclaimer be recorded, which is the case under current law, and we wanted to preserve that requirement so that we have clear land records. Section 13 speaks to when a disclaimer is barred, meaning it's no longer possible to disclaim. A disclaimer that is barred is not effective as a disclaimer, which again means a refusal to accept the property. However, it will constitute an effective transfer to the persons who would have received the property had the disclaimer been effective. And this was a provision where our eyes were crossed when we first read it, and there was some discussion trying to digest and understand what was happening here. And what it is saying is if you botch your disclaimer, okay, it's not going to be effective as a refusal, as a non-transfer, as stated earlier in the statute. Instead, what you're effectively doing is receiving the property and then transferring it to the people that would have received it had the disclaimer actually been effective. So that has, of course, tax law implications, but also it just um, provides some clarity between the parties as to who has the right to the asset. Um, so, again, this section is speaking to what can bar a disclaimer, but time is no longer one of those elements for state law purposes. Um, so there is another change here for Vermont, or a change to Vermont law. So we followed the Uniform Act language here, and we submitted a comment on this, which you may not have in front of you, but so we followed the Uniform Act law, which is a change to our existing statute, which under existing law, there is a bar of a disclaimer. You can't disclaim property to the extent of a lien on the property. We didn't understand the purpose of that provision. The Uniform Act didn't have any such limitation. We went with the Uniform Act. And it's my understanding that the Bankers Association supports the bill, so I assume it didn't cause them any heartburn either. But I did want to point that out because it is one of the deviations from current state law.
Can you share where exactly that is? The page and line number?
So, let's see. So I think this is more of an absence of language, right? So our current state law says you can't do this, but this section, so it's 4113, which begins, it's page 13, line 13 is where the section begins. And so there's no language there speaking to property that has a lien on it. And so that under the current statute, no, I guess I don't have that citation. I think it's in
So just so I'm understanding, it's the overall change, because the lien provision isn't mentioned, is that if this were to pass, then you could disclaim property that has a lien on it?
correct.
Thank you.
And I don't have the current law section number at my fingertips, but I can get that to you if you like.
No worries. Thank you.
So section 14, the wording is a little dense, but what it's really saying is that if you make a disclaimer that is effective for federal tax purposes, then it will also be effective for state purposes. So even though the state law requirements no longer parrot the federal requirements, if you have met the federal requirements, then you will also have a qualified disclaimer for state law purposes. The reason for that being the federal law requirements are more rigorous than the state law requirements. Section 15 says that, in fact, you can record a disclaimer if if there's an instrument transferring property that you're disclaiming that could be recorded, then you can record your disclaimer. But we did, as mentioned earlier, in the section on delivery, we did require that disclaimers of real property interest be recorded. So section 15 says that the failure to record does not affect the rights of the parties. But again, we did require it elsewhere because we want people to record so that we have clear land records. Section 16 says that if you are still within the 9-month period for disclaimer under the current law, that if this law passes, you would still have the right to disclaim. But if your 9-month period had already expired, this law doesn't revive your right to disclaim. And section 17, relation to electronic signatures and Global and National Commerce Act. I know nothing about that act. However, my understanding is that the provisions of this statute are a deviation that is a permissible preemption of that federal law. And so the federal law says if you state in your state law that you are preempting those provisions, then that's okay. And so the uniform law included it, and we've included it here. So the remaining sections 18 through 21, I don't think there's anything we need to talk about there.
I think severability clause, I'm not sure that it's necessary. I think we have a all-encompassing severability clause that applies to anything and everything that we pass. I don't know if I'm oversimplifying it, but I think it's in Title I, Section 215, maybe 250. But either way, it's a small technical change that we probably make.
I'll leave that one to Eric.
Committee, any questions for Matt? Okay. Well, thank you, Matt. We're going to try hearing from some other witnesses too, just to make sure we're fully wrapping our heads around this and, what it, the full implications of it. So yeah, thank you for the walkthrough. Bob or Chris, I see you folks in here. Did you want to chime in at all?
Sure, yeah. For the record, Chris Delia, President, Vermont Bankers Association. So as is the tradition when we have bills like this, working with the Bar Association, we circulated it to our folks in the trust community who responded back with no concerns about the bill. The one thing I am just going to double check on is the lien piece that was just mentioned by Matthew, but aside from that, we see no issues with the bill, and I'll get back to you as soon as I can on the lien piece.
Sounds good. Thank you.
Thank you.
Committee, any questions first? Okay, thanks. Bob, did you have anything or?
No, I just defer to Matt Getty and the committee.
Okay, great. Thank you. So committee, we try to think of any other witnesses that we can get in on this, just to broaden our perspective on it. And we do have Katie McClinn coming in at 11:30. So if we can be back right at 11:30, talk about H545. I think it's doing a drive-through flyby. something along those lines.
Drive by.
Yeah.
Maybe we don't want to do those.
So yeah, 11:30, we'll be back.